5 seconds to go. Start. Therefore, it is to be presumed that while enacting the Order 2019 and providing Clause 213 of the Order 2019, the legislature was conscious of the provisions of the earlier Act, Act 2013. Under the circumstances also, with respect to the lands acquired under the State Act of 1990, Section 24(1)(a) of the Act 2013 shall not be applicable at all. Even otherwise, it is required to be noted that in some of the writ petitions there was an order of status quo, maybe with respect to the possession. It is to be noted that the notification under Section 4 and declaration under Section 6 of the State Act of 1990 was a common notification declaration. Therefore, there was impediment on the part of the authority in declaring the award. The original writ petitioners cannot be permitted to take benefit of the order of status quo obtained by some of the original writ petitioners and thereafter to contend that as the award has not been declared, they shall be entitled to the enhanced amount of compensation under the provisions of the Act 2013. In the case of Indore Development Authority versus Manohar Lal and others 2028 SCC 129, it is observed and held by this court that lapse of acquisition takes place only in case of default by the authorities acquiring the land, not caused by any other reason or order of the court. If it was not possible for the acquiring authorities for any reason not attributable to them or the government to take requisite steps, the period has to be excluded. In case the authorities are prevented by the court's order, obviously, as per the interpretation of the provisions, such period has to be excluded. The intent of the Act 2013 is not to benefit landowners only. The provisions of Section 24 by itself do not intend to confer benefits on litigating parties as such, while as per Section 114 of the Act 2013 and Section 6 of the General Clauses Act, the case has to be litigated as per the provisions of the Act 1894. It is not the intendment of the Act 2013 that those who have assailed the acquisition process should get benefits of higher compensation as contemplated under Section 24. It is not intended by the provisions that in case the persons who have litigated and have obtained interim orders from the civil courts by filing suits or from the High Court under Article 226 of the Constitution should have the benefits of the provisions of the Act 2013 except to the extent specifically provided under the Act 2013. In cases where some landowners have chosen to take recourse to litigation and have obtained interim orders restraining taking of possession or orders of status quo, as a matter of practical reality, it is not possible for the authorities and government to take possession or to make payment of compensation. Stop.